Therefore, I want to draw attention to a fundamental problem in the relationship between divine retributive justice and the concept of a penal substitute in the penal consequence version of PSA. In so doing, I'll take a look at two central claims in William Lane Craig's recent work, Atonement and Death of Christ. On a number of occasions, Craig insists that the penal consequence version of PSA easily escapes conceptual difficulties due to the fact that God does not punish the innocent Christ for the sins of humankind. In doing so, he does not offer much of a deliberation on such a view. However, I argue that simply bypassing the punishment problem with penal consequences will cause significant difficulties elsewhere. Thus, in this short paper, my primary focus will be on the intelligibility of the claim that in the penal consequence account of PSA, Christ indeed satisfied divine retributive justice as a penal substitute. As such, I'm giving a new criticism, specifically aimed at the penal consequence version of the doctrine that many have thus far considered to be less problematic. In order to do so, I'll first quickly clarify the distinction between the definition of punishment and the desert-based theory of retributive justice. Second, I'll evaluate two of Craig's legal justifications for the penal substitute in light of contemporary penal theory and retributive justice. I'll then argue that the penal consequence account of PSA is ultimately the justification for setting aside retributive principles. Most crucially, the penal consequence form of the doctrine fails to fulfill retributive requirements and is a justification for judicial mercy. Punishment in the theory of retributive punishment. It's common practice in legal theory to define what constitutes punishment before one can justify such punishment. There are 5 fairly standard criteria for determining an act of punishment. I'll use one widely referenced and recent critical view of the theory of punishment by David Boonin in his work The Problem of Punishment. 1, punishment must inflict harm upon the offender. In addition to the harm inflicted in some way, it must make the offender worse off, either by imposing something bad on them or depriving them of some good. 2, punishment must be an intentional harm. The offender is punished when affected intentionally, not merely as an incidental byproduct or side effect. 3, punishment must be intentional requital harm, looking backward to the offense committed. 4, punishment must be reparative. It must be communication of condemnation. And 5, punishment must also be authorized. Legal punishment can only be administered by those authorized to do so. This feature clarifies the distinction between lawful execution of punishment and the vengeance of a private citizen upon a perpetrator. These 5 tenets give a good working definition of punishment. Punishment is the intentional harm inflicted on an offender by an authorized entity that is both backward-looking at an offense and reprobative. Now that we've defined punishment, the justification for retributive punishment can be established. In so doing, I'll focus primarily on the work of well-known legal theorist and retributivist Michael Moore, who has arguably provided one of the most sophisticated modern versions of retributive punishment. Although retributive punishment theory takes on several forms, desert-based retributivism has been given extensive attention in legal theory. In general, the retributive theory of punishment argues that the guilty deserve to be punished by the state or authority, and that punishment is an intrinsic good or a non-instrumental good. Defenders of this view maintain 2 distinct claims. 1, punishment is just because and only because the guilty offender deserves to be punished. And 2, the offender must be punished proportionate to the moral gravity of their offense. The retributive justification for punishment is that the offender deserves to suffer punishment because they have the moral responsibility to suffer punishment. In other words, an offender should be punished because the moral offender deserves it. No further defense is necessary. The assumption is that this is an intrinsic value. Punishment is good in itself. Furthermore, retributive punishment does not satisfy desires for vengeance for the victim or the desires of society at large, nor does the execution of punishment by the state restrain vigilante acts of violence, nor is retribution expressivist. As such, the desert-based retributive theory of punishment does not justify punishment by aiming for some internal good or external good. Rather, the desert-based version of retributivism is grounded on a moral principle that offenders deserve punishment. Retributive justice and the penal substitute. With the distinction between punishment and retributive punishment in place, we can now evaluate Craig's legal case for a penal substitute in the penal consequence account of PSA. Although Craig's aim is not my own, he seeks to justify penal substitution, whereas I seek to determine whether or not penal substitution in the penal consequence account of PSA can satisfy retributive justice. Nevertheless, I'll consider 2 features of his argument that will help us to ascertain whether or not the notion of a penal substitute meets the necessary conditions for retributive punishment in the case of the penal consequence view of PSA. We saw above that the widely held definition of punishment is intentional harm inflicted upon an offender by an authorized entity that is backward-looking at offense committed and is reparative. Thus, punishment must be upon the guilty for the act to be considered punishment. However, in the case of Christ's penal substitutionary work on the cross, it is a universally orthodox Christian belief that Christ was innocent of any sin. Thus, the argument goes, Christ cannot be punished. Since the central claim of PSA is that Christ becomes the sinner's substitute and frees the sinner from the debt of punishment, Christ in some fundamental way must pay the sinner's debt. The penal consequence view seems to afford such a shift away from issues concerning punishment and avoid such conceptual concerns. Craig contends that, quote, a penal substitution theorist who holds that God did not punish Christ will be unfazed and perhaps even welcome such a critic's objection to the punishment of Christ. And such a theorist, if he wishes, may simply use a different word than punishment to characterize Christ's suffering, end quote. While in some broad sense this is true, the definition of punishment is moot. This semantic suggestion underestimates a broader issue, namely whether or not a different characterization of the suffering of Christ, no longer punishment, can satisfy the requirements of divine retributive justice. So, while it may be true that the penal consequence account does not have to defend the particular definition of punishment and justification for punishment, it seems to be a misstep not to attend to whether penal consequences can meet the demands of retributive justice. By arguing that the concept of punishment can simply be replaced with the concept of penal consequences or suffering, the judicial context shifts from a retributive legal system to one that does not require a debt of punishment to satisfy justice. Suffering alone does not meet the conditions for an act to be considered punishment, which calls into question how the suffering endured by a penal substitute can, in any sense, be retributive. Given that Craig claims that God's justice is retributive, this presents a problem. It seems Craig conflates two important but related concepts, punishment and retributive punishment. On the one hand, punishment is defined according to a particular number of principles, just as we've seen above. These principles ostensibly can be replaced with some concept of penal consequence or penalty, which removes the necessary condition of the guilty being punished. On the other hand, retributive punishment is a specific justification for such defined punishment. Maybe meeting the necessary conditions for an act to be deemed legal punishment does not necessarily meet the same requirements for the punishment to be categorized as retributive. So, while one may be able to use a favorable definition of punishment or utilize the concept of penal consequences to defend the coherence of a penal substitute, the definition of retributive punishment is not fungible. The fundamental contention of retributive punishment is that the guilty party is indeed the recipient of punishment. And if retributive punishment is the satisfaction of retributive justice, it seems, according to Craig's view of divine justice, and in the case of the penal consequence account of PSA, that the retributive justice of God is frustrated or suspended. Simply stated, if one is to characterize the passion of Christ in non-punitive terms, then the suffering of Christ cannot be the result of retributive justice. A second issue Craig addresses is the claim that penal substitution is unjust. How can a perfectly just God punish the innocent Christ for the sins of others? Similarly to the concern with the concept of punishment above, Craig acknowledges that this objection can only defeat versions of PSA that argue Christ is punished. Thus, in the case of penal consequences, it is not unjust for Christ to voluntarily take on the suffering due to the sinner. God is not punishing. Christ willingly suffers or pays the penal consequences due to the debt of sin. With this simple statement in place, Craig quickly moves on to justify the punishment form of the doctrine and examine the retributive nature of God's justice. Although his particular aim is to argue that God is just in punishing an innocent and withholding the deserts of the sinner, Craig appeals to various forms of retributive justice, seem to present an unintended problem pertaining to retributive justice and the demands therein in the case of the penal consequence view. First, he argues that retributive justice is part of the divine nature. However, this is best understood with two distinctions. Positive retribution, which holds that the innocent should be punished because they deserve it, and negative retribution, which holds that the non-guilty should not be punished because they do not. Craig then asserts that God is a positive retributivist, but a qualified negative retributivist, qualified in that God prohibits humans from punishing the innocent. As such, God in retributive just deserts the sinner. However, he reserves the right to punish Christ as he sees fit. God's good and perfect will is justified in relaxing the demands of positive retribution, so God's purposes may be accomplished. Second, Craig draws on the epistemological distinction between prima facie and ultima facie justification to further substantiate his claims. For the retributivists, there are always good grounds for justifying punishment. The offender is guilty and must receive their just deserts. Thus, the state can lawfully punish. However, retributive punishment is a prima facie justification because there is also the possibility that there are other reasons to withhold the execution of punishment. So, while prima facie has to do with the belief having its grounds in all things being equal, ultima facie justification can be understood as all things considered. As such, punishment can be lawfully waived due to certain extenuating circumstances. In the case of the atonement, the demands of positive retribution, which holds that the guilty must be punished, are waived in the cosmic act of the redemption of humankind. Therefore, while God is essentially a positive retributivist, Craig argues that the intervening moral considerations, the destruction of the entire human race, for example, justify foregoing the prima facie demands of positive retribution. Thus, Christ is innocent of any wrongdoing, was punished in the place of the guilty, justified ultima facie. So the reasoning goes, in particular circumstances, punishment may not be required of the guilty, all things considered. And an innocent can, in fact, be punished instead. In this sense, Craig concludes that the substitutionary atonement of Christ allows God to relax, quote, far less of his essential retributive justice for the sake of mercy, end quote. This last statement represents a classic way in which PSA advocates defend the penal substitute. However, the theory of retributive punishment knows no such concept of mercy. Punishment has intrinsic value, it is good in itself. Thus, mercy would be suspending the intrinsic good of punishment. As such, the concept of mercy seems misplaced. Indeed, it is the antithesis of retribution. As initially noted, the lines of reasoning above explicitly pertain to a punishment view of PSA, not a penal consequence account. Nevertheless, in the case of the penal consequence account of PSA, it seems hardly plausible that God, as a positive retributivist, would accept the idea that an innocent could be merely a bearer of penal consequences in place of the guilty, when rather it says that either the guilty party or the innocent proxy pays the debt of punishment. Penal consequences, as it's argued, are not the same as punishment. If true, how can God, as a positive retributivist, accept a substitute that endures merely penal consequences? There is, after all, no execution of punishment. It seems this presents a rather significant obstacle for those who find comfort in the penal consequence view of PSA and also claim God as a positive retributivist. The positive retributivist reserves the right to suspend the demands of retribution due to overriding political or social circumstances. In this case, God is lawfully justified in God's decision to forego the execution of punishment on some of humankind so that humanity may be saved from everlasting destruction, and is also lawfully justified in redirecting the penalty of sin to the innocent Christ as a substitute. However, this justification of such use of penal substitute is seemingly defensible, but the justification itself is inconsistent with the claim that retributive justice is satisfied. In fact, it is the very claim that the retributive justice of God requires qualification that betrays the ineffectiveness of strict retributive justice for the accomplishment of salvation. And if this is the case, then the penal consequence account, and arguably the punishment version of PSA, becomes an example of divine mercy, not the execution of divine retributive justice. Conclusion. Given the definition of punishment, the theory of desert-based retribution, the concept of a penal substitute in penal consequence accounts of PSA is a means to waive the demands of retributive punishment. For either there is no punishment at all, or the just deserts are redirected to a proxy and not meted out to the guilty. The concept of legal relaxation seems defensible. However, this is the justification for setting aside retributive principles, not meeting the inexorable demands of retributive justice. More critically, if we follow Craig's argument, a penal substitute is a justification for judicial mercy. If this is the case, then arguments for the essential retributive nature of God need to be reevaluated. It seems that the consequences of legally defending penal substitution in the penal consequence account of PSA inevitably undermine the species of justice that Craig claims is essential to the very nature of God. Although the penal substitute is arguably defensible, the work of that penal substitute fails to satisfy retributive justice. If this is the case, then retributive justice is not, strictly speaking, execution. If the cross is not the satisfaction of divine retributive justice, but the ultimate expression of divine mercy, then perhaps the cross of Christ is an indication of retributive justice itself, not as an expression, or as an indictment of retributive justice itself, not the expression of it or validation of it. Offer Craig's atonement in the death of Christ. To be sure, I have my differences with what Craig offers therein, and there are ways in which my thinking about this doctrine, the relevant biblical texts, and so on diverge from his own. But on the whole, I'm quite amenable to his legal defense of PSA. As such, this paper takes the form of something more like a friendly amendment than a withering critique. Particularly, I'd like to spend some time ruminating on a rejoinder to PSA theorists offered by fellow panelist Oliver Crisp, who's looking very different today. In his recent participation in Atonement, Oliver has voiced doubts that the, quote, liability of penal debts can be transferred from one individual to another, end quote. For this reason, he writes elsewhere that God's holding Jesus liable for humanity's sins, despite Jesus' personal blamelessness, would be nothing more than a mere legal fiction. Craig calls these comments confused, pointing out that, quote, on the view that Christ is legally liable for our sins, Christ being declared legally guilty is no more fictitious than an employer's being held legally guilty by the court for wrongful acts done by his subordinate, end quote. But Chris further claims that, quote, if a murderer were to have the culpability for his crime transferred to another, surely we would think this would be a mockery of justice. Yet this is just what is involved, end quote. There are some PSA defenders who take there to be a transfer of guilt involved in the atonement, but Craig is not one of them. Instead, Craig's interest is in the idea that legal guilt for human sin could be replicated and imputed to Jesus. On this view, the guilt does not leave me and go to Jesus, but rather is copied from me to Jesus. But when we tweak what Chris says slightly so as to get it to more directly target Craig's view, we get an interesting result. For present purposes, I'll call this modified claim Crisp's concern. Crisp's concern, if a murderer were able to have the culpability for his crime replicated and imputed to another, surely we would think that this would make a mockery of justice. Yet this is just what is involved in Craig's PSA. Here, I think, it is difficult to say that we see mere confusion. Rather, we see something more like moral astonishment. After all, even if we have legal examples of vicarious liability to draw from all sorts of torts and criminal law, it can't possibly be the case that we'd ever apply such a mechanism to crimes of serious murder, right? But, in fact, this both can and does happen in some judicial contexts, from which Craig draws his other elements of legal support. Specifically, this happens with the application of something called the felony murder rule. So in this brief paper, I'm going to offer an account of how Craig's PSA could use the felony murder rule to insulate itself against Chris' concern. To do this, I'll first recapitulate some relevant details of Craig's account, paying particular attention to the distinction between two species of guilt and their relation to punishment. Next, I'll offer an overview of the felony murder rule so we can see how it might be added to Craig's repertoire of judicial imagery. Here, I'll propose we think of God as choosing to, in some sense or another, be held liable for humanity's sins in virtue of being the universe's creator. But finally, I'll provide two reasons Craig shouldn't adopt this view. First, that Craig is already something of an odd man out among retributivists, and adopting this view could worsen his situation. And second, it may be that felony murder isn't actually an example of vicarious liability after all. Therefore, I conclude with the suggestion that Craig's PSA can actually best avoid Chris' concern by either slightly revising its stance on retributivism or becoming a non-necessitarian account of the atonement. So 2, PSA and legal perspective. For Craig, PSA's conceptual core is, quote, that God inflicted upon Christ the suffering that we deserved as the punishment for our sins, as a result of which we no longer deserve punishment, end quote. The remission of liability to punishment is key for him because his exegetical and historical theological analyses lead him to think retributive justice is probably part of God's nature. Moreover, Craig contends that, quote, the essence of retributive justice lies in so-called positive retributivism, which holds that the guilty should be punished because they deserve it, end quote. As such, God's refraining from punishing our sins would be a logically impossible violation of the divine nature, not unlike God's creating a square circle. However, Craig also contends that God is a perfectly loving creator who knows that bearing the weight of punishment for our sins would crush us. And so, God provides a means by which humanity's sins can be punished without it being the case that each of us are individually subjected to the demands of God's retributive justice. Namely, God, in the Trinitarian person of the Son, bears our sins on our behalf and is punished for them. But a common retort here is that Jesus can't be punished in our stead because that's just not how punishment works according to retributivism. Only the guilty can be punished, it's said, and he's just not guilty of our sins. Craig offers multiple replies of atonement at the death of Christ, but one is particularly relevant here, namely his usage of the concept of vicarious liability. He begins by emphasizing that vicarious liability does not, quote, concern the transfer of guilt from one person to another, in the sense that the guilt is removed from one person, placed on another, end quote. Instead, as I stated briefly above, it's a matter of legal guilt being replicated in another. One example of vicarious liability in practice is the legal principle respondeat superior, or let the master answer, according to which an employee can, or equivalently authorized individual, can be found guilty of certain actions that are committed in their duties. It's crucial we understand that the employer here isn't being found negligent or complicit in their junior's actions. Instead, as Craig writes, it's, quote, in virtue of his relationship with the employee, even though he did not himself do the acts in question, end quote, that the employer is declared legally guilty. Requisite here, quote, is that the superior be so related to the subordinate as to have either the right, the power, or the duty to prevent the subordinate's wrongdoing, end quote. But there's no need for intent. That is to say, per Weck's quote, it's an example of strict liability, which Weck defines as a defendant being held liable for committing an action regardless of what his or her intent or mental state was when committing the action, end quote. We should also be clear that strict liability isn't a form of legal fiction wherein the court just pretends something is the case when it really isn't. The vicariously liable party just is guilty. To make this point clear, it might be helpful to distinguish between what we could call moral guilt on the one hand and legal guilt on the other. Moral guilt pertains to my status as one who does wrong in a broad sense, while legal guilt pertains only to my status in a narrower judicial sense. So, if I lie to my wife about the price of an academic book I'd like to buy, leading her to believe it's nice and affordable when it's really eye-wateringly expensive, I would be morally guilty because it is wrong to lie to my wife. But I'm not legally guilty because there's no sort of law against this kind of spousal deception. In cases of strict liability, the inverse is true. One is legally guilty regardless of their moral guilt. We should also note that there's a distinction within legal guilt itself between one's being culpable for something and liable for it. John Day writes that for desert-based accounts of criminal responsibility, quote, for an action that the law prescribes to be done culpably, it must spring from a blameworthy state of mind, end quote. To be liable for something, however, is just to be subject to some penalty set out by the law. Speeding tickets are a really common example of strict liability. As such, one can be liable without being culpable, but they can't be culpable without being liable. They don't come apart symmetrically. So if Jesus is held vicariously liable for humanity's sins, he is guilty, but only in the sense of his being legally liable. Is this enough to meet the demands of retributive justice, though? Answering this question asks that we ask a further one about what punishment is, given that punishment to the guilty is retributive justice's heart. It's generally accepted that punishment has to include some measure of harsh treatment, but that's not sufficient alone. So, we might ask, what is sufficient? To quote Craig, this is where the debate begins. No consensus, in fact, exists concerning the conditions sufficient for punishment, end quote. David DeLinco echoes this sentiment, writing that, quote, the persistent and pervasive lack of consensus in the literature on punishment is evident as soon as one asks what punishment is, end quote. Of course, there are widely read and popular conceptions of punishment among theorists, but the issue remains a divisive and much argued one nonetheless. One such conception of punishment with which Craig directly engages is Alec Wallen's. We can summarize it like this. Punishment is an intentional harm inflicted by a valid authority in response to some particular transgression which expresses condemnation of said transgression. So, on this view of punishment, being cognizant of the fact that there is no singular consensus view of the term to which we can appeal, is Jesus punishment? If he's held vicariously liable for humanity's sins on the cross, it looks like he meets Wallen's criteria, and so can be said to be punished. He experienced suffering and death as an intentional harm inflicted by a valid authority, presumably God, for the countless yet particular transgressions of humanity, which expresses God's condemnation of those transgressions. And so, in one sense, the demands of God's retributive justice have been met. Each human sin has been accordingly punished. But now we've arrived at the juncture where Christ's concern emerges, because we surely don't have examples of vicarious liability of the dead, right? 3, felony murder and PSA. Enter the felony murder rule. Though previously existed elsewhere, the rule is most predominant today here in the U.S., where its application generally allows, quote, anyone who's accused of committing a violent felony to be charged with murder if the commission of that felony results in the death of someone, end quote. 3 holdings from the Supreme Court directly address the application of the felony murder rule. These are 1982's Inman v. Florida, 1987's Tyson v. Arizona, and 2008's Kennedy v. Louisiana. Of these, Tyson is most relevant here. So Tyson concerned a series of events in which a group had been collectively involved in perpetrating a prison break. Though some of the group had committed murders in so doing, Tyson's defendants hadn't. Nevertheless, they'd been sentenced to death in Arizona via the felony murder rule, and they contended this sentence was disproportionate enough to constitute cruel and unusual punishment. The Supreme Court didn't agree. Writing for the majority, Sandra Day O'Connor stated that, quote, The Eighth Amendment does not prohibit the death penalty as disproportionate in the case of a defendant whose participation in a felony that results in murder is major and whose mental state is one of reckless indifference, end quote. Goyar and Binder et al. Note that lower courts have read this opinion as, quote, allowing capital punishment of any person who causes death during the commission of a felony, regardless of that person's mental state with respect to the resultant death, end quote. In other words, lower courts have generally thought that perpetrating a violent felony displays in itself the sort of reckless indifference towards human welfare which Tyson seemingly establishes a test for applying the felony murder rule. So, felony murder is apparently a form of strict and vicarious liability. It doesn't require that felonious murderers intend to commit murder, and it doesn't require that they actually murder anyone themselves. Instead, if they're appropriately involved in the commission of a murder's precipitating felony, then the court can replicate the legal guilt of the murderer in them, despite their moral innocence of the crime. Therefore, we do have an example of legal guilt as replicable in circumstances so serious as murder and punishable so severely as by death. But then the question arises how we're supposed to apply this analogy to Jesus, given that he doesn't seem to stand in an appropriate relationship to our sins to be a sort of quasi-felony murderer. Here I suggest that we might think of God as choosing to be held liable, not exactly as one who was a callous accomplice of sin, but rather as one responsible for the whole of their creation. Marilyn McCord Adams puts the matter like this, quote, God is responsible for our prima facie ruin, and yet God is the only one who can save us from degradation and despair. What we need is a transaction that puts the bigness of God on our side and channels its power to transform our relation to the material world of which we are a part, end quote. Though Adams doesn't hold to PSA, her discussion of responsibility can help us here. Application of the felony murder rule typically requires that one convicted under it must be both morally and legally guilty, just not for killing per se. But perhaps we can use for felony murder as an analogy for what occurs in the Atonement by thinking of Jesus as one who is held liable for our sins in virtue of his status as creator instead. Though God is the author of sin, God is still majorly involved in the affairs of the universe, inasmuch as it's either by God's will or permission that they come to be at all. And while divine foreknowledge and love would preclude God's being recklessly indifferent towards these states of affairs, God still creates the universe. So, maybe God relaxes the standards for vicarious liability vis-a-vis the felony murder rule in Jesus' singular case. Craig describes judicial relaxation as a judicial act in which, quote, the very thing which is owed is not paid, but in the judge's forbearance something else is allowed, end quote. And one way of thinking about penal substitution is that, quote, in the satisfaction rendered by Christ, there is a relaxation of the law and God's admission and acceptance of substitute, end quote. So, we could say that in this unique situation, the standard for who can count as an accomplice is relaxed sufficiently for our sins to be borne by the Son. This might be unthinkable in a courtroom presided over by a human judge, but in God's case, as one with absolute standards of retributive justice and gracious love, we might quote Craig again in asking, who is to gainsay him? Therefore, felony murder seems capable of analogically explaining Jesus' liability for human sin in a way that addresses Christ's concern. 4, some concerns and alternatives. When we began, I noted, however, that there are 2 reasons Craig might not want to take this path. The first was that Craig is already something of an odd man out among retributivists for accepting vicarious and strict liability. Dave points out that, interestingly and ironically, quote, defenders of retributive theories of punishment are among the severest critics of strict liability offenses in criminal law. Larry Alexander sufficiently spells out, someone's leaning on a light switch. Larry Alexander sufficiently spells out the reason why, quote, if criminal punishment is only justified if the criminal is deserving of it, and if his deserving punishment depends on his having acted culpably, then criminal punishment should never be premised on negligence or be a matter of definition. Strict liability is liability in the absence of punishment, and so it cannot follow as a matter of definition. So, where does this leave Craig? He could appeal to the distinction between positive retributivism and negative retributivism, which he makes in Atonement and the death of Christ, and the possibility that God is either only qualifiably a negative retributivist, or that God simply waives the demand of divine retributivism in Jesus' case. But, as Day and Alexander highlight, he seems right to remain he seems to remain outside of retributivism's mainstream regardless. For when retributivists center a wrongdoer's guilt as the very thing which merits their punishment, they usually accept both the positive and negative desert-based restrictions on punishment. So, since to accept vicarious liability at all is just to accept that there can be things other than just deserts which attract criminal liability, and since, as Claire Finkelstein notes, felony murder has been controversial among American commentators for years, Craig seems to have more than enough to get on with regarding his retributivism without adding an even more contentious idea into the mix. But suppose Craig likes this edition enough to think it's worth the trouble. Even in this case, it might turn out that the felony murder rule isn't as helpful as it would have seemed. And this brings up the second reason why Craig shouldn't follow the course plotted here. For, in addition to controversy about its moral validity, significant debate surrounds whether lower courts have been properly interpreting Supreme Court precedent here. For example, Binder suggests that cases such as Tyson have been interpreted by lower courts in overly mechanical ways, which miss that their intent was not to, quote, permit execution of non-culpable killers, end quote, but rather to delimit what culpability is in the first place in murder. Considering Tyson as well as the Inman case which preceded it, he highlights that, quote, because both cases concerned accomplices and intentional killers, neither courts specified whether those who killed included all those who caused death by any means within every state. Yet most lower courts have assumed that anyone causing death in any predicate felony is death eligible regardless of culpability, end quote. If this reading of the case law is right, then felony murder turns out not to be strict or vicarious liability at all. And so its utility for defending PSA evaporates. Of course, Craig could launch a defense of the rule's contemporary application to hold on to it. But is it really worth the trouble? I suggest that it isn't. For Craig has at least two other ways to avoid Chris's concern which don't require the felony murder rule. First, he could just adjust his retributivism from a positive desert-based account to a version skeptical that the wrongdoing of one alone warrants punishment. For example, he could adopt a communicative retributivism on which, quote, censure is deserved for wrongdoing, while hard treatment is best justified instrumentally for deterrence or incapacitation, or to give meaning to the censure, end quote. In so doing, Chris's concern is avoided by shifting vicarious liability's explanatory power from an account of how God deals with the guilt of sin to an accounting of how God communicates divine condemnation of sin. Or secondly, Craig could simply become a non-necessitarian atonement theorist. In this way, he'd also avoid Chris's concern because legal analogies for the atonement could be accepted as truly and merely analogies. They don't describe what God must do to redeem humanity at all. 5, conclusion. In this brief paper, I've offered a constructive response to Craig's atonement of the death of Christ by proposing a way for it to escape a criticism leveled at PSA by Chris. In order to do this, I first sketched Craig's PSA and then synthesized it with the concepts of felony murder to provide a way of ducking Chris's concern. However, I then gave 2 reasons why Craig might want to avoid taking this approach, and described 2 alternatives for undoing Chris's concern without appealing to the felony murder rule at all. My suspicion is that Craig will not like either of these alternatives. Moreover, he may well deny that the felony murder analogy works in the first place. We'll have to wait and see. But to extend the metaphor of this paper as friendly amendment, I do greatly look forward to hearing what the proverbial bill's author, pun intended, has to say.